Hello, there is.
Sir, I've shared the link.
Okay, got it. Thanks.
Hello, there is. Can you hear me? Can I start?
Next, yes, start.
Okay, thanks. Good afternoon and welcome to our webinar on the Consumer Protection Act 2019. It's a privilege to introduce the speaker for the session today, Mr. Nishant Shah, partner and co-heads the tax practice at ELP, Economic Laws Practice. Nishant has a specialization on various consumer protection law, such as Legal Metrology Act 2009, Food Safety and Standards Act 2006, Consumer Protection Act 1986, and other related laws. Nishant has also assisted several Indian and multinational firms across issues related to both direct and indirect tax applicable in India. Nishant, it's a privilege to have you for this session. Over to you. Please take it up.
Thank you, Meenakshi. First of all, thank you very much to the Retailers Association of India for giving me this opportunity to present before all the listeners. The presentation today we are doing is the Consumer Protection Act of 2019, and we've effectively titled it as Rise of Consumerism in India. The first point which comes up is, why is there a need to do this presentation? The reason being that consumerism in India is gradually growing. The current government's focus also is towards getting good quality, effective products and services with the people of India. And therefore, we have had the Consumer Protection Act of 2019, which was legislated in 2019, made effective very recently, that is in the July of this year, on the 20th of July 2020. So that's the reason why we'll be discussing on the Consumer Protection Act of 2019. What are we intending to discuss today? On the next slide, we have the different topics that we are intending to discuss today. We are going to be touching upon the Consumer Protection Act of 1986. Why was there a need to reset? Why was there a need to replace the Consumer Protection Act of 1986 with a new Consumer Protection Act of 2019? So we will be touching upon that. First of all, the introduction of Consumer Protection Act of 86, and why was it becoming outdated? Why was there a need to replace it? Having decided that it was to be replaced, what is it that we are replacing it with? What are the new concepts that are being introduced in the Consumer Protection Act of 2019? We'll be looking into that. The Consumer Protection Act of 2019, one of the significant reasons is the evolution of the e-commerce. And therefore, we'll be touching upon the e-commerce rules as well, which are part of the Consumer Protection Act of 2019. We'll be going into the dispute resolution mechanism, which is announced under the Consumer Protection Act of 2019. We will be touching upon certain interplay between the Consumer Protection Act and other legislation. And this is one of my favorite sections, because while we talk about the Consumer Protection Act, please be aware that there have already been various legislations existing, and you are already undertaking compliance under various other legislations. If you are a business, and if ever you are faced with a consumer protection dispute, please also be aware that somewhere or the other, under some other legislation, you must have been complying, you must have taken certain steps which will come to your help in protecting against the consumer protection dispute. Lastly, since there is a new act, obviously there is a need for a new compliance, and therefore, what is it that businesses, organizations need to do effectively in a manner to protect themselves if ever a dispute were to arise under the Consumer Protection Act? So that is what we will be covering today. Moving on to the Consumer Protection Act of 1986. Before we go into this, let me just explain that, you know, it is not that the every country has a consumer protection law, a special law for consumer protection. For example, in a lot of Western countries, there is no specific legislation for consumer protection. It is under the law of torts, which is a law, which is rather a principle of law or body of laws that enable people to seek compensation for any wrong committed to them, where they have been faced with some sort of a issue. Then they can claim the claim compensation, and that is under law of torts. India also has number of legislations which automatically cover the law of torts, and you have the Contract Act, you have the CPC, CRPC, the Environment Protection Act, all of which have principles of the law of torts. Uh, but the bigger issue which comes up is that under all of these legislations, for a remedy to be obtained, you need to go to the courts. And as everybody here is aware, our legislative system requires a lot of time before the court finally gives out a ruling. Therefore, while under other legislations there may be justice, it's a delayed justice. To overcome this aspect, this specific aspect of an expedited resolution or an expedited redressal of grievance, there was the need of a special act called the Consumer Protection Act, and we had the Consumer Protection Act of 1986 more effectively than anything to expedite the redressal, grievance redressal mechanism for the consumers. So we have the Consumer Protection Act of 1986, which was there. Again, now when we talk about the Consumer Protection Act of 1986, it is not the very first act in relation to the consumer protection. In fact, a lot of other legislations which existed prior to the 1986 Act already had the elements of consumer protection. For example, if you talk about the Contract Act of 1872, and I'm talking as back as 1872, the Contract Act of 1872 does not give you clauses which should be there in a contract. It does not draft a contract for you. What does it do? It says that when there is a contract between two parties, other than what is mentioned in the contract, there are a few elements around the contract, around the circumstances, which come into play and which have to be respected to, which is nothing. So a buyer of goods from a seller, it is sort of a contract. It's a contract of purchase of goods. So again, the principles of contract act come into play even in case of that situation. Similarly, when we talk about the Sale of Goods Act 1930, okay, if you see section 16 of the Sale of Goods Act 1930, it very clearly said that there is no warranty or condition as to the quality, fitness, etc., unless by the buyer. So what does section 16 say? Section 16 says that if, say, you enter into a shop, okay, the shop is shop of leather goods. You go there and tell them that I want to buy a bag. If the board outside the shop says that this is a shop for leather goods, it is expected that the bag that you'll receive is a pure leather bag and not a resin bag. But still, having entered the shop, you come out having been told that it's a leather goods, but you find out that it's not leather goods, then you can have a remedial measure. That remedial measure, you don't need consumer protection. You can still go under Sale of Goods Act. So what I'm trying to say, Sale of Goods Act also had certain provisions, but same way you had the Agricultural Produce Act or the Drugs and Cosmetics Act or the MRTP Act, Competition Act, the legal metrology, which talks about label and things. All of these legislations have provisions for the protection of consumers. But a remedial measure under any of these is a long drawn process. And therefore, to overcome the long drawn process, it is important that there is a mechanism which is introduced. And therefore, we had the Consumer Protection Act of 1986, which created that mechanism. Now, what were the salient features of that legislation, of the Consumer Protection Act? The salient features of this legislation, obviously, that it resulted into an action being taken by the government on a much quicker basis. It led to significant redressal of consumer disputes. There were various forums under which the consumer protection was created. It reduced the delay. More effectively, what are the specific issues because of which a significant issue could come up were clearly articulated from the consumer's perspective. So for example, say if we talk about defect in goods, And defect in goods may not apply to everyone and anyone, but a consumer buying goods, a defect in goods. So the concept of defect in goods was introduced, or deficiency in service. These are concepts which were very effective from a consumer redressal perspective, and therefore those were incorporated in the Consumer Protection Act of 1986. Accordingly, we had the Consumer Protection Act of 86. What did the COPRA, as we call the Consumer Protection Act, introduce for the first time? It brought in the definition of consumer. So, therefore, this was a legislation which could be brought into play only in relation to disputes between a a seller of goods and a buyer for consumption purposes, not for business purposes. For business purposes, they had a lot of other legislations. They had the Contract Act, the Sale of Goods Act, various other civil, even the CPC, CRPC has provisions. But this was specifically where it was a B2C transaction. The act was also extended to services where B2C services were procured. Where there was a defect in goods or deficiency in service, concept of what is defect in goods, deficiency in service was for the first time introduced. A restrictive trade practices concept was brought in. That means if somebody is hoarding goods, etc., he is taking up a practice which is a restrictive trade practice. And we'll be touching upon these a little bit more in detail. You had unfair trade practice which was being brought in. More importantly and very significantly, district, state, and national consumer forums were set up. So a consumer could straight away reach out to a district, state, or national consumer forum. He did not need to go through the whole process of going into the courts, the small causes court, or the High Court and Supreme Court to get a redressal of mechanism. Directly from these forums, he could get it, and that resulted in expeditious resolution of the issues. There was no requirement of stamping of complaints. Earlier, any dispute to be filed, the whole stamping process, etc., was also resulting into delay in the filing of a complaint or in taking up a dispute. But before these forums, if a complaint was filed, no such concern was coming in. Finally, there was a very specific provision which says that the provisions of COPRA are in addition to and not in derogation of the provisions of any other law for the time being enforced, which means if you had the 1986 Act of COPRA and at that point in time you also had the Telegrams Act, if there was some delay in the telegram, then it was an implication which was coming through under telegram as well as under the COPRA Act. Action could be taken under both the legislation. Basically what it said is that just because an action is being taken under the Consumer Protection Act of 1986, you do not have a remedy before the other authority to say that no action should be taken here, because otherwise it will result into dual action. Very important point again, because today also when we'll talk about the Consumer Protection Act of 2019, you'll realize that this provision now with so many other regulatory authorities, the TRI, you have the FSSAI for food purposes, you have the legal metrology, there could be a proceeding running under any of those. Along with that, a proceeding running here, you could have a proceeding running under GST. Let me give you a simple example. There will be some issue where somebody will bring about a complaint about excess charge of price. Now, if there is an excess charge of price, you may have a proceeding running under consumer protection, whereas there may be a proceeding also running under GST, under the anti-profiteering or something like that. Can you give a ground under anti-profiteering that no proceeding should run under anti-profiteering because there is a proceeding running under consumer protection? No, you will not be able to give such a ground. So there is a clear derogation of so the provisions of COPRA are in addition to and not in derogation of the provisions of any other law for the time being enforced. So that is so far as COPRA is concerned, the Consumer Protection Act of 1986 is concerned. But what we are here today to discuss is the new Consumer Protection Act of 2019. And why was there a need for the Consumer Protection Act of 2019? Multiple reasons. To start with, even the redressal mechanism under COPRA was not effective enough. It was not fast enough. It had various constraints. One of the significant constraints was that the complaint was required to be filed at the location of the other party, opposite party or other party as they call, that is the manufacturer of goods or the supplier of goods. Whereas under this legislation, it has been made that where the complainant is located, it can be filed. The second point is consumer markets of goods and services have undergone drastic transformation since the enactment of COPRA. What do I mean by that? What I'm trying to say is COPRA is a 1986 Act. There has been so much evolution of the consumer preferences, consumer needs, etc., that there was a need for determining when is a certain consumer right affected. So let me give you an example. Today, when we talk about, say, kitchen appliances, there are kitchen appliances for every different activity that you do. If you're blending something, you have a blender. But if you're removing juice from something, you have a juicer. While same thing can be used for multiple purposes. But if you're mixing something, you have a mixture. So for every activity which is carried out, there is a separate appliance which is there. Now, if one appliance is wrongly used for the other and the appliance stops functioning effectively, can you bring about a complaint? In that case, you can't bring about a complaint. But you will not be able to bring about a complaint, or a business or a trader will be able to safeguard themselves only if they have very specifically made instructions or descriptions along with the sale of the appliance, that this appliance should not be used for any purpose other than so and so, so and so. And therefore, if it is used for any other purpose, you have safeguarded yourself. So that is another important aspect, the change in consumer preference. I can give you n number of examples of shoes. There are now shoes for running, there are formal shoes, casual shoes, shoes for playing tennis, football shoes. In fact, there are specific shoes for playing kabaddi. So there also there is specialization. Now, if kabaddi shoes are used for something else and if they break, the manufacturer or the trader can say you did not use the shoes for the right purpose. So consumer markets for goods and services have undergone drastic transformation since the enactment of COPRA. The next one, the emergence of global supply chains, rise in international trade and rapid development of e-commerce. So global supply chains have made it very critical that you are getting identical similar products, some of which are true of the original brand, some could be very similar but not of the original brand. And therefore, and these may be, one will be from one country, the other from the other country. You need to be very clear as to what product are you buying, at what price, and for what purpose. And unless the consumer is able to prove that he had picked up the product for the purpose that he wanted, the complaint brought by him can be defended. I'm mentioning here certain issues is because it is important to understand the overall philosophy of the consumer protection law. And as we go further, I will also harp upon this, that please understand, it is the dispute which a complaint has been filed by the consumer. And typically courts, forums, everyone will be always lenient towards the consumer. If you see the whole plethora of judgments that have been passed so far, you'll realize that the courts are always lenient before in favor of the consumers. Therefore, always important to understand and identify where is your line of protection and how best can you safeguard your business, your operations from a consumer complaint. Lastly, the concept of misleading advertising is a new concept which has been introduced within the which has been introduced within the consumer protection law, and which brings in specific aspects of what is misleading advertisement, what sort of advertisements are supportive, what sort of advertisements are permitted, what are not permitted. With the concepts of telemarketing, multi-level marketing, direct selling, e-commerce, you have concepts of influencers on YouTube, on the YouTube, on and TikTok, etc. All are causing
अभी न्यू नहीं
sorry, I think there is some disturbance. May I request for muting? Yeah. In addition to that, we have various other issues which have come up. There are other factors. For example, the concept of caveat venditor. Caveat venditor is seller beware. That was a concept earlier existing. Now the concept is, earlier the concept was buyer beware. That when the buyer is buying something, it is the buyer's responsibility of examining whether he is buying the right product that he needs. The concept has changed. Now it is seller beware. The buyer has come to you with a request. You make sure that you are making available to the buyer exactly what he's asking. And if you have not, if the buyer wants to return the goods, it will be your responsibility to accept the return of goods. Again, another specific provision incorporated under the Consumer Protection Act of 2019. Evolution of the different transactions and transaction structures I've already discussed, technological development, the e-commerce and other things that have also I mentioned. Last one, influence of government and various recent regulations. Again, very important. A number of regulations have been brought in, have been introduced, and all of these regulations go to regulate the different operators. For example, you have the civil aviation regulations. Those are for airlines. But if you have faced certain concern, can you bring about a complaint under the Consumer Protection Act while they are safeguarding under the DGCA, Director General of Civil Aviation? Yes, you can. You have the TRAI, the Telephone Regulatory Authority of India. Now, can you bring about a complaint if your signals are not proper or your calls are dropping? Yes, you can. And can TRAI also regulate them? Yes, they can be. So because of these regulations also, it became important that the consumers recognize their rights, and we as businesses understand how best to draw a line where we are at least safeguarding our operations from a consumer complaint that is likely to come about. Moving on to the, so this was to understand the overall philosophy of Consumer Protection Act. We are now moving into the act, which is the point of discussion, the Consumer Protection Act of 2019, which has been introduced. There are a lot of new concepts which have been introduced under the Consumer Protection Act of 2019. It's important that we understand these concepts, because while the other legislations talk about larger disputes, we may in for a consumer complaint just because of an item that we've sold, or a product that has been transported or shipped, or a packaging that has gone wrong, and we may have a significant quantum of penal consequence that may come about. So let's understand the Consumer Protection Act. But before I go into this, I would also just once more want to reiterate that generally in a consumer protection dispute, like I said, the forum is lenient towards the consumer. More importantly, the onus typically always lies on businesses to prove that they were not negligent, or that they had provided the right product as asked by the customer. And how do you prove that is what we will discuss and deliberate as we go through this presentation. So, as I mentioned earlier, that in light of the evolution of the concept of consumer protection, the change in trends, the consumer preferences, the change in the method of marketing, advertisement, etc., there was a need to revamp the consumer protection law. And therefore, we had the Draft Consumer Protection Act, which was passed by the Parliament in August of 2019. However, made effective from the 20th of July 2020, and that's where it becomes effective. Similar to the 86 Act, the provisions of the Consumer Protection Act of 2019 are also in addition to and not in derogation. And therefore, can there be simultaneous two proceedings going against you? Yes, there can be. In fact, let me tell you, as we go through further in this presentation, I will harp and highlight on this, that the chances of two or multiple parallel proceedings running here are much higher, because they have now introduced a new regulator for consumer protection called the Central Consumer Protection Authority. And one task of the Central Consumer Protection Authority is that if there is a complaint filed, and the complaint is against a business which is also regulated by another regulator, the CCPA is obligated to refer the matter to the other regulator. So that means the CCPA is required to go to the other regulator and tell the other regulator that so and so business has not been following certain norms. You please look into that and inquire into it. So therefore, not only that you will have a proceeding running because of a consumer complaint, you may have another parallel proceeding running under another legislation because of a consumer complaint. Now, what are the new concepts, new provisions added under the Consumer Protection Act of 2019? Let's first talk about the new concepts. The new concept, the concept of product liability. Today, the concept of product liability has been existing in a lot of developed countries for quite some time, but it is being introduced for the first time in India. And it includes the provision of product recall. Today, when a consumer brings in a complaint, legal counsels of a lot of multinationals will be having stressful, sleepless nights, just because there is a dispute which could involve product liability, which means it is a liability for a defect in a product. And under the current legislation, the product liability can be brought about not only against the manufacturer but also against the product seller. So I know that a lot of our listeners today are not purely manufacturers, but they could be sellers जो import करते हैं और बेचते हैं, या तो trading करते हैं या तो goods बेचते हैं. बेचने वाले को भी product liability impact हो सकता है. They are called as product sellers, and therefore will include product liability. उनके सामने भी, उनके against में भी complaint file हो सकती है. Second, concept of unfair contracts. Unfair contracts, they have defined certain situations in which a contract will be called as unfair contract, and we'll be touching upon that. Misleading advertisement. आज तक इंडिया में जब भी एडवर्टीजमेंट कोई करता था तो एडवर्टीजमेंट ठीक है नहीं है वो रेगुलेट करने के लिए कोई ऑफिशियल लेजिस्लेशन नहीं था. एस्काई कोड था, पर एस्काई कोड इज अ कोड फॉर अ बंच ऑफ पीपल विच इज अ वॉलंटरीली एक्सेप्टेड कोड. अब जो कोड बनाया गया है विद दिस लेजिस्लेशन कमिंग इन, एडवर्टीजमेंट को रेगुलेट करने के लिए स्पेसिफिक प्रोविजंस इसमें इनकॉर्पोरेट किए गए हैं. प्यूनिटिव डैमेजेस. Till date, wherever there was a consumer protection complaint, normally the complainant was made good the price of the product or compensated for direct damage caused because of the product. But now there can be punitive damages. For example, that if he has had harassment, mental torture, etc., there could be additional cost paid given to him just because of that. Last one, it incorporates the concept of mediation. मीडिएशन. सो इफ अ कंज्यूमर फाइल्स अ कंप्लेन, पहला चांस दिया जाएगा कि कंज्यूमर और जो विक्रेता है, जो बिजनेस है, कारोबार वालों को और कंज्यूमर्स को मीडिएशन का एक अपॉर्चुनिटी दी जाएगी. अगर मीडिएशन से इशू रिजॉल्व हो सकता है तो पूरा केस फाइल नहीं होगा, डिस्प्यूट आगे नहीं जाएगा. According to me, this is a very important concept and will bring about a big relief to businesses who will not now need to go through the entire rigmarole of proceeding. But at the same time, consumers will also have a chance to hold and come across and hold discussions with businesses. In addition to these new concepts, there has been expansion of existing concepts. And what are the expansions? The concept of deficiency in services has now been expanded to include negligence. आज तक ऐसा था कि आपने नेग्लिजेंट रहे हैं तो वो डेफिशिएंसी नहीं है. अगर कोई प्रोडक्ट में खराबी है या तो काम करने में खराबी है तो ही उसको डेफिशिएंसी गिना जाता. पर अब अगर आप बेध्यान रहे हैं तो भी उसको डेफिशिएंसी गिना जाएगा. एंड डेलिबरेट विथहोल्डिंग ऑफ रिलेवेंट इंफॉर्मेशन. आप कोई सामान बेच रहे हैं, उस सामान में कुछ खराबी है या तो उस सामान का उपयोग किसी तरह से करना चाहिए या तो उस सामान के बारे में कुछ बताना चाहिए. अगर वो नहीं बताया गया है तो उसे डेफिशिएंसी या डिफेक्ट गिना जाएगा और इसके अगेंस्ट में कंप्लेंट फाइल हो सकती है. Therefore, disclosure will become very important. How you disclose, where you disclose, when you disclose will be upon the businesses, but you make sure that your disclosing is very important. In fact, इस एस्पेक्ट पे we are working for a number of businesses to ensure that they are undertaking the disclosures effectively and appropriately so as to avoid any such consumer complaint. The concept of unfair trade practice now also includes sharing of personal data given in confidence by the customer. कस्टमर का पर्सनल डेटा अगर आपके पास आया है तो आप और किसी के साथ भी शेयर नहीं कर सकते हैं. मैं आप एक एग्जाम्पल देता हूं कि हमारे एक क्लाइंट के वहां प्रॉब्लम हो गई थी. उन्होंने लॉयल्टी स्कीम्स अनाउंस करी थी. लॉयल्टी स्कीम्स के नीचे कुछ फॉर्म्स वर फिल्ड एंड प्रोवाइडेड टू देम. दैट फॉर्म, द डेटा विच वाज अवेलेबल was collated by the parent company for multiple loyalty schemes that they were running. Now, the loyalty related data was collected from the consumer by the first entity, but then shared with the parent company because they were collating all that data. Somebody could file a complaint to say that you are not allowed to share my personal data. Even if you've collected just the data of his name, address, phone number, etc., that is also personal data. You are not allowed to share that. Unless while collecting the data, you make a very clear disclosure that this data collected will be further used for so and so purposes and may require to be shared. Again, where you are saying and may require to be shared, you cannot keep it open. You need to say shared only for so and so purposes. Ambit of consumer rights widened to include products in addition to goods and services. Products का मतलब क्या होता है? That so far goods and services were covered, but something where it is goods as well as services. Say for example, you have appointed someone to provide painting services and the company comes and brings their own paint and paints it. There is goods also where they brought in the paint and then applied this. The ultimate outcome of that is a product. And if there is any defect in the product, because there were certain issues where they said कि नहीं ये तो हमने तो ठीक से किया था, वो पेंट में खराबी थी, इसके कारण मेरा पेंटिंग खराब हो गया. Nothing doing now. If ultimately it's a product, both aspects are to be covered. The new legislation also brings in the new regulator, the Central Consumer Protection Authority. This is a new authority, and let me tell you, it will increase the effectiveness of the legislation much higher than by multifolds than what it was earlier, because one of the tasks of the authority is to support and assist the consumers who till date were not having the capability or the wherewithal to file a complaint. So now a consumer who has an issue can just go to this authority, and the authority will now handhold the consumer to ensure that a complaint is filed, or the consumer or the authority can also on its own suo moto bring about a complaint in certain cases where the consumer has conveyed to the authority. So therefore, very important point to understand that the effectiveness of this legislation will be much higher, and the consumer is likely to become much more active under this legislation because of the creation and existence of the Central Consumer Protection Authority. Lastly, certain changes that have been brought about, the jurisdictional authorities which were there, those have undergone some changes. There is a level at which one is, like I mentioned earlier, consumer जहां रहता है वहीं का वहीं वो कंप्लेन फाइल कर सकते हैं. तो अगर कोई कंज्यूमर से फॉर एग्जांपल असम में है, असम से वो ट्रैवल करके कर्नाटका आए हैं, कर्नाटका से उन्होंने कुछ खरीदी करी है, वापस असम गए हैं, वो प्रोडक्ट ठीक से नहीं चल रहा है, they can file the complaint in Guwahati, and the supplier in Karnataka will have to carry out the compliances required or argue out the matter before the forum in Guwahati. Second, the amount limits have been varied so that large complaints up to a larger quantum can itself be filed in the district itself. All the limits have been increased, because earlier the concept was that if your total complaint value is about a higher amount, then it had to be going to a higher forum. That has now, since the values have been increased, even a complaint of a larger quantum, and the measurement is the value of the goods involved. There have been specific changes in the e-commerce also, and we'll be touching upon that in the later part of this presentation. Moving on, the concept of consumer. Who is a consumer? Consumer is anyone who buys any goods for consideration paid or promised to be paid or partly promised to be paid, or avails any services. But he has to be and includes a user of goods or beneficiary of such goods when such use is made by the approval of such person. That means एक जन ने गुड्स खरीदे हैं पर किसी और को यूज करने को दिए हैं, तो जो यूजर ऑफ गुड्स है वो भी कंज्यूमर ही बन जाएगा, वो भी कंप्लेंट फाइल कर सकता है. लेकिन if the goods have been given to someone without the permission of the person who purchased the goods, then it will not be. So for example, I bought a scooter, my scooter was parked below my apartment, and somebody stole the scooter, he went away and he met with an accident because the scooter brake failed. Can he bring about a complaint? No, he cannot bring about the complaint. He did not use the scooter with my approval, and therefore he is not a consumer. Consumer includes consumers of goods, services on online transactions, offline transactions, tele-shopping, etc. However, consumer does not include a person who purchases goods and services for business purposes. तो अगर आपने गुड्स मैन्युफैक्चरर से ट्रेडिंग के लिए खरीदे हैं, तो आप सीपीए के नीचे कंप्लेन नहीं ब्रिंग आउट कर सकते हैं. लेकिन आपसे अगर किसी ने कोई कंज्यूमर ने खरीदा है, तो जो कंज्यूमर है कैन ब्रिंग अबाउट अ कंप्लेन अगेंस्ट यू और अगेंस्ट द मैन्युफैक्चरर और अगेंस्ट बोथ ऑफ यू ऑल. Again, where a purchaser has purchased for business purposes, but who is self-employed. So for example, a doctor who is running his own practice, he has bought a stethoscope, and with the stethoscope he checks, he will be considered as a consumer. If the stethoscope is faulty, he can bring about a complaint against the seller of the stethoscope or and against the manufacturer of the stethoscope. So that is the concept of consumer. Moving on, we come to the concept of who can file the complaint under the Consumer Protection Act. The consumer obviously can file, a voluntary consumer association can file, the central or state government can on their own also file, one or more consumers can file. I have already mentioned CCPA, the Central Consumer Protection Authority, which is a now new authority under the legislation, they can also file. A legal heir or legal representative of a person can also bring about a complaint. There are two new additions. A parent or a legal guardian in case of a minor can also file a complaint. There was in fact a case where a chocolate was bought by a parent and given to a child. The child had food poisoning. The question was whether the parent can bring about the complaint because the parent was the buyer, if you see the definition of consumer, and the child was not the user but the consumer. The use was by the parent to give to the child. So they said that the child should not be covered. The answer was that no, the child will be covered. Now, to make it clear, they have specifically brought it within the legislation itself. The CCPA also can suo moto bring about a complaint. Another point to be noted is that are there subrogation rights? Can the rights of the consumer be subrogated in the sense that can your right to file a complaint be subrogated to somebody else? For example, and there has actually been a case in this situation also, that there was a five-star hotel where somebody in a car went to the hotel, he gave the car for valet. When he came back, his car was damaged. He wanted to bring about a complaint against the hotel, but he had insurance cover under that. So he did not bring about a complaint. He rather filed an insurance claim. The insurance company wanted to file a complaint against the hotel while they were paying the claim. Could they have brought about? The courts have held that yes, the insurance, the claim, the ability to file a claim or the capability to file a claim can be subrogated by the consumer to the insurance company, and the insurance company can bring about the complaint. So therefore, the rights of subrogation are permitted. So that is on complaint. Let us now see what are the causes of complaint. The causes of complaint are violation of consumer rights. If any of the consumer rights are violated, what are consumer rights? Consumer rights are right to have certain goods that they want, rights for the goods to be made available at an appropriate price, rights for the goods to be explained exactly what sort of goods, the goods to be at proper price, the proper quantity, etc. These are various consumer rights. To know what sort of goods should be available, to know whether the goods are hazardous. These are consumer rights. So if, like I said, that if any information is withheld and the consumer is not made available either of the goods or the information about the goods or the supply of goods or the pricing of goods, it could all be violation of consumer rights. Misleading advertisement, again, a new concept. We'll be touching upon it in detail, but very important concept for the first time introduced under this legislation. Unfair trade practice. Unfair trade practice was a concept already existing. The concept has been expanded by introducing various concepts. We'll be touching upon the new introduction also. Restrictive trade practice. अगर किन्होंने गुड्स खरीदे हैं और भर के रखे हैं ताकि उसका प्राइस बढ़ जाए और फिर वो सेल करेंगे, तो that's a restrictive trade practice. Hoarding of goods is a restrictive trade practice. And if a consumer comes to know that he is required to pay a higher price because the goods have been held up and not made available, and therefore it's created unnecessary scarcity or artificial scarcity, it is called restrictive trade practice. There are many other examples of restrictive, but this is one simple example. Unfair contracts, again a new concept introduced under this legislation. We'll be touching upon what is unfair contracts and how do unfair contracts operate. Defective goods, deficiency in service are concepts arising from again product liability, and we'll be touching upon what are these. But these could be again reasons for complaints to be filed. Hazardous goods being made available or supplied without proper information thereof, again could be a reason for complaint. Excess price charged. Excess price charge, there have already been a number of complaints earlier also under the earlier legislation, but if a consumer believes that there is an excess price charge, there could be a complaint. And finally, product liability. Like I mentioned, we'll be touching upon that much more in detail, but any harm caused to a consumer because of a deficiency in a service or defect in a product will result into product liability, and the consumer will have an ability to claim on account of such product liability. Now, out of these various reasons for which a complaint can be filed, the CCPA can bring about complaints suo moto in case of violation of consumer right, misleading advertisement, unfair trade practice are the typical concepts in relation to which the CCPA can, on its own, as well as product liability, the CCPA can suo moto bring about a complaint. Now, why these? These are because these are concepts where to the world at large there is sort of a concern which is arising. But if you see issues where, for example, deficiency in service or defect in goods, a defect in goods has to be borne by an individual or by the user, and therefore he has to prove that there is a harm caused. That the CCPA cannot prove. Since the CCPA cannot prove that, the CCPA cannot bring about a complaint against that. And therefore, it is needed that this concept, those complaints only the CCPA can bring about from on its own basis, that is suo motu. So moving on, let's touch upon some of these concepts. Unfair trade practice. Unfair trade practice. Now, what is unfair trade practice? Unfair trade practice is a trade practice which, for the purpose of promoting the sale, use, or supply of any goods or the provision of any service, adopts any unfair method or unfair or deceptive practice, including making false statement about goods or services. What is important to note is a trade practice which for the purpose of promoting. Therefore, it has to be a practice. And what is a practice? Practice is not a one-off event. So therefore, you went to a consumer, came to a store, he picked up some goods. Say by error, the shopkeeper ended up charging him little amount extra. Even the consumer did not realize, or the shopkeeper or the business did not realize. It is not a practice that the businessman is following. Therefore, a consumer cannot bring about a complaint on that. It has to be proved that it's a practice, it's an ongoing thing which is recurrently and regularly followed by the business. Only then it can be an unfair trade practice, and only in these situations. Which situations? Making of false statements. He makes a false statement about goods or services, that the goods are uh, better than what they are actually supposed to be, or any such similar statement. Falsely publishing advertisement for sale of goods or services at a bargain. So if any advertisement has been published which in the normal course would not have been uh, true, then again it is a concept of unfair trade practice. Conduct of contest by promoting any product except as prescribed. So where a contest can be promoted or can be conducted on basis of certain aspects, then it is. But unless such a contest has been carried out in the true sense where it is a contest, it can be again considered as an unfair trade practice. So therefore, a lot of contests, etc., which are just with a view to promote sales and which do not actually result into a benefit to the winner or the person who comes out effective in the contest, cannot be publicized as a contest. You can run the schemes. A lot of businesses run various schemes, but do not call it as a contest. You run it as a scheme, that is more preferable. Non-compliance of goods with the standard of the competent authority. So as I mentioned, that there are various regulatory and competent authorities that come out with specific standards. If you do not follow those standards, again there could be a concern. Refusal of providing goods or services with the intention to raise cost. Again, I said hoarding. Manufacturing of spurious goods. Not issuing invoices. The last three, not issuing invoices, refusal to take back, and disclosing personal information are the new additions under this legislation. So with GST law coming in, issuance of invoices anyways compulsory. The Consumer Protection Act has also incorporated that. Another aspect that the Consumer Protection Act has incorporated is the compulsory requirement to accept back the goods which are defective or deficient and refund the consideration within 30-day period. Again, a very important, and a lot of businesses may need to rejig or alter their internal policies to ensure that they meet with this aspect. Lastly, disclosing of personal information. I have already touched upon that a little bit in detail earlier when we spoke. But again, if your systems are resulting into collation of personal information from your customers, make sure that those are only sitting with you and those do not get distributed or shared with anybody else. Otherwise, it could be a cause of complaint. Moving on, we'll go to the certain illustrative examples. I don't want to take too much time on this. The consumer protection legislation is wide enough. It has lots of concepts, and 1 hour time period is pretty small, but I've tried to compact everything to ensure that I touch upon all the significant portions. So I may run through some of the slides a little bit faster. Uh, Going to the previous slide, on the unfair trade practice, let me give a few examples of this. Certain contests, etc. So there was a contest, Gar Bulao Sab Lucky Ban Jao, and where they were saying that you order a certain burger at a price of 20, and even for that, you will get the burger free if you are this. Now, they did not finally announce who were the winners of that contest. And therefore, there was a doubt that whether there was a winner at all, or it was nobody got the prize at all. And somebody had filed a complaint, and the person was successful to say that no, they cannot run this kind of. Similarly, there are a number of other examples of unfair trade practice, but it is important to understand that before you bring about a scheme, policy, etc., make sure that you are not breaching the line of consumer protection just with a view to ensure larger sales. Moving on to the next one, we come to the concept of misleading advertisement. Now, a misleading advertisement is one which has one or more of the attributes which can be construed as misleading. But before we go to what is misleading, like I mentioned, this is for the first time that a legislation is administering an advertisement. So first, let's understand how is the advertisement defined under this legislation. It's given in the blue banner at the bottom of the slide. An advertisement has been defined to mean any audio or visual publicity, representation, endorsement, or pronouncement made by means of light, sound, smoke, gas, print, electronic media, internet, or website, and includes any notice, circular, label, wrapper, invoice, or such other documents. So please understand, it's such a wide definition that even a wrapper or a cover or a circular or a flyer which you may have along with this, that is also advertisement, or done by light, sound, gas, smoke, print. So any sort of method of adopted to do this will still be advertisement. And if you're doing anything, so what is important to understand and be careful is that you may not be wanting to do something with a view to advertising it, but it will still be deemed as advertisement, and it will be considered as misleading advertisement if it falsely describes a product or service, gives false guarantee which is likely to mislead the customers, conveys an express or implied representation leading to unfair trade practice, and deliberately conceals important information. Now, specifically for this group of listeners on this today's presentation, a lot of you all would be distributors of products which are manufactured either in the country or manufactured outside the country. As product sellers also, you are subject to consumer protection legislation. There are a lot of situations where we've also seen that the manufacturer who may be in a third country, he grants you a certain amount which can be expended on various advertisement. They may prepare the advertisement in their country and make it available here for you to display, publish it. For all of these advertisements, you will be considered as the endorser and you will be liable as to the appropriateness of the advertisement. Otherwise, any consumer complaint will be against you. So therefore, very important to be careful and aware as to an advertisement which has been provided to you or which you are preparing does not cross the line to become a misleading advertisement. The advertisements earlier were being monitored by SKI code. Now it has gone beyond. It has now become part of the legislation. As I already mentioned, there are in fact specific advertisement guidelines under the Consumer Protection Act, which we'll be touching upon. But moving on to the next one, there are a few examples of misleading advertisements also which have happened. I won't take too much time, but let me just explain one. In case of General Motors, they had advertised to say on the road, off the road, and somebody drove it off the road into a little dirt road, and the car broke down. And they had filed a complaint to say that when you advertise, why did you say on the road, by the road, off the road, and the dirt road? And we did it and it's broken. So you should have told us that it can be off the road, but it has to be a proper, at least a wooden road or something. So there was a concern. These are examples of misleading advertisement. Moving on, as I mentioned, the new Consumer Protection Act has advertisement guidelines also. Very important we understand that our guidelines that we are following advertisements. If we are publishing advertisements, we are creating advertisements, they are in line with the guidelines that have been published. These are draft guidelines. The government had kept it open for collection of comments on that. The date was up to the 18th, I think the 19th of August. However, since the draft guidelines have yet not been finalized, I would suggest that if any or all of you all have any comments to make, please go ahead and make a comment or a suggestion to the authority so that those can be incorporated. Now, what are the draft guidelines? The draft guidelines are basically in relation to that the advertisement should be truthful and honest, not mislead consumers, not present rights given to consumers by virtue of a law as a distinct feature. So for example, you may say that, oh, you buy this product and the product comes with a certain packing. Now, if the product had to be sold with the packing, you cannot advertise to say that because you are buying the product, we are giving you the packing. That would be a misleading advertisement. Or not suggest that the claims made in it are universally accepted if they are significant division of information. So for example, somebody says that, okay, this is a water purifier, you have that, you will become healthy and strong. But if there is a contention going on that, you know, if you continue to have water and your immunity may come down, then you cannot give this kind of a advertisement saying that only what you are saying is the universal truth. Similarly, there are other aspects. What is important is that these guidelines have specifically set out the roles and responsibilities of a manufacturer, service provider, product seller, and also the advertising agency. So even when the advertisement is to be published, any advertisement agency will also have to be careful to ensure that they are dealing with appropriate, that, you know, they are publishing only those advertisements. And also the endorser. Endorser is the you know, the TV personalities or film stars or cricketers who endorse your products, or even any individual. If the endorser comes across in the dress of a doctor, he better be a doctor. If he's not a doctor, he cannot be endorsing a product as a doctor. Or in the course of endorsement, he need not say that I am a doctor and I'm doing this. Similarly, various kinds of advertisement, they have very detailed guidelines on imitation of advertisements, that if you're making advertisement similar to another advertisement, it should not you know, create misconception for the consumer. Or comparative advertisement, that if you're saying that my product is better than his, make sure that you have exact and factual information to prove what you're saying. Bait advertisement, एक आइटम लो उसके साथ दूसरा आइटम फ्री है, वो एक्चुअली फ्री मिल रहा है तो ही आप बताइए, अदरवाइज उसको मत कहिए. Surrogate advertisement, certain things are not allowed to be advertised, but if they're advertised in the form of another product, make sure you have sufficient sales of those products. Puffery, if you're saying this is the number one or this is the best, you have enough proof to prove that it is the best or it is number one. Otherwise, say that it is one of the best or it is among the top ones. Free claims, if you're saying something is free, make sure it is completely free, because if you're going to be charging for packing, transportation, any sort of taxes, etc., then it is not free. Advertisement targeted at children, please make sure that the advertisement does not cause any harm, that the, even if the children tries to imitate that, it does not cause any harm. And prohibited advertisement, advertisements which may cause someone to take up a criminal action or something, will be all prohibited, or any indecency in advertisement will be prohibited advertisement. Moving to the next one from the draft guidelines, this is only talking about the SKI code, that there was already an SKI code. Certain concepts of the SKI code are already incorporated in the draft guidelines, but more important is, earlier courts have held that an SKI code is not a legislation, and if somebody violates an SKI code, does not mean he should be punishable under law, which will now not be true. If you violate the advertisement norms under the Consumer Protection Act, you will be punishable under law because it is a law. The SKI code was just a regulatory guideline, was not a law, but the Consumer Protection Act is a law. Moving on, the differences between the Consumer Protection Act, we can skip that. We'll come to the product liability concept, again a very important concept. Product liability means responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold, or deficiency in service relating thereto. So then what does product liability? It means that it is the responsibility of the manufacturer or seller of any product or service to compensate for any harm caused to the consumer for a defective product or a deficiency in service. So there are very specific criteria provided for product manufacturers, service providers, and product sellers, along with exceptions on product liability. Of course, there are certain exceptions. Now, what is important is to compensate for a harm caused, and therefore for a consumer to bring about a complaint which is a product complaint, they will need to clearly identify that there is a harm caused. And what is a harm caused? Harm caused includes damage to property or damage to self, other than the damage to the product itself, the personal injury, illness or death, mental agony and emotional distress, or any loss of consortium service or any other loss. And therefore, I say that, now the with product liability coming in, your total damages that can be claimed has swollen multiple folds, because now they can even claim damages for mental distress and all of those aspects. Product liability action is a complaint filed by a person before a district court, state commission, or the national commission, as the case may be, for claiming compensation for the harm caused to him. The district commission now has the power to determine and award compensation to consumers in respect of product liability action. Since product liability is now been brought in, even at district level, a product liability action can be brought about and a compensation can be claimed. In fact, there is no formula or methodology prescribed, and therefore, in case the administrator is very sympathetic towards the consumer, he may grant a much larger compensation also, and we may have to be struggling with it. So therefore, very important to understand the product liability concept. Next, unfair contracts. What is an unfair contract? See, we already had contracts, and if you have a dispute in relation to a contract, you can go under the Contracts Act or the Sale of Goods Act. But those are contracts where it is a business to business contract. In relation to an issue which is faced by a consumer, he does not have remedy under any of those legislation, and therefore it was very important to bring in the concept of unfair contract. And let me read out what is an unfair contract. You'll realize that it is a very wide scope. A contract between a manufacturer or trader or service provider on one hand and the consumer on the other, having such terms which cause significant change in the rights of such consumer, including requiring excess security deposit from the consumer, refusal to accept early repayment of debts without a penalty, unilateral termination of contract without reasonable cause, imposition of unreasonable charge on consumer obligation or condition which puts such consumer to disadvantage, assignment of a contract to the detriment of the consumer without his consent, imposition of penalties such as disproportionate to the loss or breach of contract. Now, all of these, if you see, are very wide concepts. In fact, let me take an example. Say, imposition of unreasonable or unilateral termination of a contract without reasonable cause. Okay. Now, lot of your businesses, etc., you all may be having various schemes, etc., running, or you all may be having various vouchers which are issued. Most of these vouchers, when you see, they have one condition behind, which says that the issuing authority, that is the company, uh, reserves the right to withdraw this facilitation at any point in time. Now, can someone who has got this voucher, he is not even intending to use the voucher, but because the voucher has this clause mentioned there, can he bring about a complaint saying it is unilateral termination of contract without reasonable cause? It gives you the power for that. Therefore, it is an unfair contract, and therefore I want to bring about a complaint. Yes, he can. But can businesses protect themselves against that? Yes. The answer is yes, you could very effectively protect. The need is to review and ensure that you do not consider that resulting into a unilateral termination of contract. So that's on unfair contracts. Moving on, we will come to so these were the significant concepts under the consumer protection law, which are the new concepts which have been introduced, which I thought are important ones. There is a lot more under the Consumer Protection Act, and if I was to cover that, even a whole day would be difficult to cover all of these aspects, but these are important concepts which I thought should be highlighted effectively. Lastly, I'll just touch upon 3-4 specific issues. There are specific rules in relation to e-commerce products, and these rules have already been notified and these are up and active. These rules talk about various specific roles and responsibilities of e-commerce operators. So a lot of your businesses you all may be doing on e-commerce basis also. In such case, there are specific roles and responsibilities given for the e-commerce operator, the marketplace operator, and for the sellers on those specific marketplaces or through e-commerce activities. Important that we run through all of these rules, etc. It's not enough time for me to run through each of these rules, but each of these rules have significant nitty-gritties which need to be taken care of. We have, on the basis of a broad reflection, given some of these rules on the next slide. You'll see that there are very detailed rules, detailed roles and responsibilities for sellers on marketplace. Same way, there are duties and liabilities for inventory e-commerce entities. Similarly, those are for people who run the marketplace. Now if you see some of these aspects, you are required to prescribe all the requirements. So under legal methodology, whatever is required to be there, you are also required to put it on the website. So if there is a country of origin, you are required to mention the country of origin also on the website. The price and other things are without question, but certain other details also are required. So if in the course of your business you are required to use the e-commerce route, please make sure you have read these rules and are complying with these rules. In fact, our team has recently been significantly busy just helping various businesses to ensure that their e-commerce operations are complied with these rules. Moving on, that was from the e-commerce perspective. We will now touch upon the dispute resolution under the consumer protection. I don't want to take too much time, but two important points to highlight here is the new legislation allows the complainant to file the complaint in the location where the complaint is. Second, the regulatory bodies now include the CCPA, that is the Central Consumer Protection Authority, which can suo moto bring about a complaint and which can also uh, uh, administer some of these complaints filed. And I will touch upon this. The slide also brings about the limits up to which the complaints can be filed. When the complaints are filed, the limit is to be valued on the basis of the value of goods and not the damages claimed. Going ahead. Uh, this is a flow of what are the regulatory bodies. So if a consumer is to file the consumer complaint, the consumer complaint should be filed. It can be filed either with the CCPA or it could be filed with the CCPA or the consumer forum. If it is filed with the consumer forum is compulsorily required to uh, ask the consumer and the business to go in for mediation. If the mediation is successful, the matter is resolved. If the mediation is not successful, then the prescribed procedure for adjudication of the complaint is taken up. The consumer could very well go directly to the CCPA, and the CCPA could itself undertake an investigation of the complaint, come out with an inquiry report, and then adjudicate on its own, or refer it again to a consumer forum, and the consumer forum will take it up. The CCPA, while carrying it out, will also be required to inform the other regulatory bodies who are impacted or who are to take into consideration the operation of the businesses. So long drawn process, but it has been made much more effective now with the mediation being included and the CCPA being another authority which can not only file complaints but also adjudicate complaints. Mediation, I've already touched upon it. Just the important point is that at the first hearing, you will be asked to go for mediation before the district commission. Then the parties will give a consent that yes, they agree to go for mediation. Ongoing, they will be in writing. Within 5 days, the mediation will be closed. So not only it is expeditious, it is also effective from a cost and conclusion perspective. Moving on to the next one, like I said, another very important aspect, any complaint filed under the Consumer Protection Act, businesses typically are regulated by a number of other legislations within the country. And under each of those legislations, you are required to undertake number of compliances. You may not have today put across all systems for consumer protection, but if you had effective and robust systems under other legislations, I can tell you that a lot of documents, information, processes, etc., followed thereunder can come to your rescue on a complaint under the consumer protection. But it is important that you highlight and identify. In fact, like I mentioned on the advertisement and on the unfair contracts, our team has also been busy with a lot of businesses, helping them in putting standard operating procedures in place to ensure that if there is a complaint filed, how is the complaint to be dealt with? And in that comes into all of these aspects that under other legislations, what are the different documents, etc., that you are maintaining, which can be brought into use to safeguard or to defend against a complaint which is filed by a consumer. So it becomes very important, be it the IT Act, be it under the drugs and cosmetics, ये हर एक लेजिस्लेशन के लिए, इनफैक्ट ये तो सारे लेजिस्लेशन स्पेसिफिक है, आईटी एक्ट सबको नहीं लगेगा, पर अगर आप ई कॉमर्स का कर रहे हो तो आईटी एक्ट के नीचे ऐसे ही आपको कुछ फॉलो करना है। अगर आप फार्मास्यूटिकल एंटिटी है या तो आउटलेट भी है तो भी आपको ड्रग्स कॉस्मेटिक के नीचे अंदर कुछ कुछ फॉलो करना है, तो उसके लिए आपको मेंटेन करना है। अगर आप यू आर सेलिंग, डिस्ट्रीब्यूटिंग, मैन्युफैक्चरिंग फूड आइटम्स, again you are complying with certain requirements. Moving on, the other legislations which again have an interplay, GST, almost everybody is required to comply with the GST, and for GST you maintain certain quantum of information, documents, etc. There again all of these will come to your rescue, come to your assistance if there is a complaint filed. But how do you use them, how effectively do you maintain them, and how can they come to your rescue becomes very important under a system which is required to be understood and implemented by you within your organization. Legal metrology. In fact, the largest piece of consumer protection was earlier already part of legal metrology, but still you are required the Consumer Protection Act. If you have not violated legal metrology, you have a very strong evidence to safeguard yourself against this. On the finally, just touching upon some aspects, there are certain participants who had requested that while we are doing consumer protection, we also touch upon legal metrology and FSSAI related issues. I'm not going into detailing of those, but just broad pointers. Under the legal metrology, there was a confusion or there was a concern whether the brand name owner, the name of the brand name owner instead of the actual manufacturer can be declared. Having analyzed the legislation things, we are of the view that yes, the brand name owners can be declared so long as the consumer has someone to go back to. You need not compulsorily declare the actual manufacturer. The declaration of the brand name owner should be good enough. Having said so, under FSSAI, that's not true. So if your product is a food product, this would not be true what I mentioned. Nomination of a director or other employee. The legal metrology law very clearly permits you to nominate a director. It is suggested and requested that every business, please review your legal metrology registrations. Do you have a nomination? If you do not, please make sure that you have nominated a director or an individual from your organization, because having not done that, for smallest of the small issue which is identified or picked up by one of your parcel picked up by the legal metrology officers in the field, a notice will be issued to all your directors, and you surely want to avoid that, and therefore there is a request that you please look into. It's a very good practice, you should follow that practice. Clubbing of offenses for compounding. If there is an issue picked up by legal metrology, please understand that it is not just one packet that you may have in the market. It may be with multiple locations in multiple outlets, etc. In such a situation, what happens? Will you face multiple proceedings? Answer is yes, there will be multiple proceedings, but legal metrology law has a compounding provision. The compounding provision is not in the central legislation, but almost every state legislation, every state has come out with compounding guidelines. Please make sure that you are aware of those guidelines, and in an unfortunate situation where you are faced with a legal metrology issue, you take resort to the compounding or the clubbing provisions to ensure that it is an efficient and expedited resolution of a complaint. Testing of samples option, again this is from very important from a FSSAI perspective. Under FSSAI, lot of times you may have officers who come across radio premises and things and ask various questions and things. They may take away samples for testing in the laboratory. When they come out with report, please understand that there is always an opportunity under law with the seller, with the businesses, to carry out their own testing also. So therefore, always opt for that option, carry out your own test, because if the test by the officer comes out to be negative, you will have an argumentative ground to say that that's not the only result. In fact, you also have a result which is rather positive. Lastly, from an FSSAI perspective, again, in case of a lot of additives or various ingredients, etc., we have seen a lot of complaints being filed or cases being filed by the authorities saying that what you're using is unsafe, and therefore it could have very rigorous repercussions. Please understand, under FSSAI, there is very clearly a concept of unsafe and substandard. Something which is unsafe results into a very high level of penal consequence or including prosecution. and in fact it results into initiation of prosecution. But not everything is unsafe. More often than not, we've realized that it falls under substandard, but the authorities may come across saying it is unsafe. It will be upon you to put across to them that it is not unsafe, it is substandard. If it is substandard, you typically have mitigation avenues, opportunities by which you can mitigate to come out of the penal consequence. These were some of the aspects on legal metrology in FSSI which we were asked to touch upon. Lastly, don't want to take too much time, but what businesses, companies should do need, like I mentioned, your contracts, advertisements, documents, processes, etc. need to review all of them. If at all there were a concern from a consumer complaint, please have clear systems, SOPs available, that when the complaint is filed, you are not at that time now struggling to identify how to redress the. You need to have SOPs ready so that it will be much smoother and much effective. Have checklists to identify what are the obligations of the CCPA, and whenever a new advertisement is going on, new contract is going on, new scheme is going out, is it within the parameters of the CCPA? Please make sure of that and ensure compliance with the standards, quality checks, etc. under other regulations that are applicable to you, because any concern under those regulations can result into being a CCPA complaint also being brought about, and you surely want to avoid that. Or a complaint under CCPA, under CPA, consumer protection, the CCPA will have the authority to go to your regulator and ask for a parallel second proceeding also to be commenced. So these are pointers for businesses to keep in mind. With this, we come to the conclusion of today's presentation. I see that there are a few questions. If you have any further questions, please put it in the comments section, and we will be happy to answer some of these questions. I am joined by my colleague, Pranav Pagaria. He will be also helping me in responding to some of the questions. So there is the first question, which is flat buyers who bought flats prior to RERA will have any rights under CPA, I am assuming. Platform to submit his grievance in this forum available, kindly advise. Pranav, you want to take up that one?
Yeah, Nishant, sure. So, with respect to this question, surely there are, as Nishant mentioned during the course of the discussion, that this regulation is in addition to any other regulation, and therefore, even if the matter is before RERA and the builder may not have got registered under RERA, you still have an independent option to proceed under the Consumer Protection Act, and you can very well file a complaint against the builder based on the cause of action. So possibly because of the delay or any other aspects of unfair contract, whatever could be the situation, you can consider what is the cause of action and file an appropriate complaint under the Consumer Protection Act.
In fact, as we speak, Pranav and the team are working in relation to a similar issue. And you'll be surprised to know that the NCDRC, which is the National Commission, has been lenient towards the flat buyers and has been issuing decisions in favor of the flat buyers. So therefore, specifically to answer the question, I would say that you may not have a resolution under the RERA, and therefore the resolution under the Consumer Protection Act becomes a very effective and specific resolution. There is a next question: is product liability applicable to retailers or only manufacturers? In that case, how can a retailer protect himself from such claims from consumers? How does this law relate to apparel textile industry? So for the first one, yes, the product liability applies to retailers as well as manufacturers. In fact, more often than not, if you are a distributor or retailer, you would typically be having an agreement or something with the manufacturer. In case you have such an agreement, please make sure that in case of a complaint, a consumer complaint, if you're taking an indemnity, please make sure that your indemnity clearly covers the further aspect of any penal consequence, etc., arising because of a product defect, because it will be more often than not that the product defect is a manufacturing defect and not yours. So if a complaint is filed against you, unfortunately you will be the one who will be answerable in that complaint. But if you have a appropriate clause within your contract with the manufacturer, you will be in a position to be indemnified in this regard. How does this law relate to apparels or textile industry? From an apparels and textile industry perspective, the law will apply like it applies to any other legislation or any other product, and therefore, depending on what is the nature of transaction, if it is a B2C transaction, it would effectively apply. I assume these are all the questions right now that we have. I'll hand it over back to Retailers Association of India with a thank you to all the participants and the audience for being patient and listening to me. And thank you to RAI for giving us this opportunity to present before the audience.
Thank you so much, sir. It was a very knowledgeable session. Very, very, very interesting, and we learned a lot from it. Thanks so much for your time.
Thank you.